Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. We are covering the Idaho 4 defamation case styled as Scofield versus Guillard. In our last episode, we had gone over the first couple of pages of the plaintiff's trial brief, which gives the plaintiff's side of the story, how the plaintiff is framing this case. If you have not yet had an opportunity to review our prior content, please do, because we are now going to pick up where we left off at the top of page number 3, and specifically at section 2, procedural background. Here we see plaintiff is writing that in December 2022, Professor Scofield filed a 2-claim complaint. The first claim was for defamation related to Ms. Guillard's false statements that Professor Scofield participated in or orchestrated the unalivings. The second claim was for defamation related to Ms. Guillard's false statements that Professor Scofield had an ongoing affair with a student. Both claims advanced defamation per se as a theory. In June 2024, the court granted Professor Scofield's motion for partial summary judgment and motion for leave to add a request for punitive damages. In its decision, the court held that Ms. Guillard published her statements about Professor Scofield. Ms. Guillard's statements about Professor Scofield were false, and Ms. Guillard's statements about Professor Scofield were defamatory per se. The only question left for trial was the amount of damages, compensatory and punitive, that Professor Scofield can recover. Next, under the applicable law section, this is helpful because we've received some comments. Why is this case even in federal court? I thought that a defamation case is a state claim. It should be prosecuted in Idaho state court, not federal court. We're going to learn right here why. The court is exercising its diversity jurisdiction, so Idaho law governs Professor Scofield's claims for both compensatory and punitive damages. Citing here to Sedid versus Vallis, this is a 2013 Idaho district that is federal court case, and the plaintiff is summarizing this case for the point that she wants here, applying Idaho law to assess damages in a defamation case. Also citing to Roost Project LLC versus Anderson Construction. This is also a federal case. We know that by the FSUP 3D that you see right there, and D Idaho 2020. That's telling us that this is a District Court of Idaho decision, not a state decision. And the plaintiff here is citing to that case, claims for punitive damages are substantive, and Idaho law is therefore controlling in diversity cases. Compensatory damages are an element of a defamation case. And then citing to Veracity versus USA Today, Idaho 832, 2019. Accordingly, Professor Scofield carries the burden of showing her compensatory damages by a preponderance of the evidence, citing to Polini versus Albertsons, Inc., and then gives the case number. This is a federal case out of the District of Idaho, 2003, holding that a plaintiff must establish damages in a defamation case by a preponderance of the evidence, and also to Polini versus Albertsons, Inc., and this is a Ninth Circuit Court of Appeals case, federal case, 2007. And then going into a preponderance of the evidence means proving a fact is more likely true than not, citing to U.S. versus Highsmith. This is a Ninth Circuit appellate case from 2001. And now turning to the facts here as the plaintiff sees it. Since Ms. Guillard's statements are defamatory per se, Professor Scofield can, quote, receive an award of general damages, end of quote, as compensation, instead of needing to prove special damages, citing to the Sedid case above. And then in parentheses, the proposition, according to plaintiff, Idaho follows the common law rule allowing plaintiffs to receive an award of general damages without proof of special damages in defamation per se cases. So if we could just take a moment to summarize everything here. First, why is this in federal court? She's telling us here why. It's also stated in the complaint. Diversity of citizenship is federal jurisdiction. And where a party can show that both sides, that's every plaintiff, sometimes there's multiple plaintiffs, and every defendant, multiple defendants sometimes happens in cases that are in federal court under diversity jurisdiction, that both sides are completely diverse, meaning every single citizen on the plaintiff side and every single citizen on the defense side are from different states. Here, she's pled in the complaint that she is, that's the plaintiff, a citizen of the state of Idaho, whereas the defendant is a citizen of the state of Texas. But the analysis isn't done there. There's got to be two things proven. First, complete diversity of citizenship, and then second, the amount of damages pled has to meet a procedural floor of $75,000, and she's pled more than that. She's stated in the complaint that she's seeking that amount. So she's satisfied in pleading in the complaint that this is appropriate for federal court, invoking diversity of citizenship jurisdiction. Now, what she's then saying is citing to Idaho law on defamation cases, what constitutes defamation. There's a famous case, it's called the Erie Doctrine, that says when there's a diversity case, you follow procedural rules of federal court, but substantive law, i.e., what do you need to show for defamation? You follow Idaho law for that. And then she's giving the various evidentiary standards. For example, in stating that she bears the burden by a preponderance of the evidence evidentiary standard to prove certain of her damages, she's got to bring this evidence admissible into court and bring it before the jury. This is very different from if you followed the Idaho versus Koberger case. You know that in a criminal case like that, the burden upon the plaintiff, i.e. the state of Idaho, was much higher. It was beyond a reasonable doubt evidentiary standard. So that, in a nutshell, very, very rudimentary level, in my opinion, is what the plaintiff is saying here and giving her side of the story. Now she turns in the next paragraph. Punitive damages in Idaho are governed by, and this is a statute, Idaho Code Section 6-1604. To recover punitives, the claimant must prove by clear and convincing evidence oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damages is asserted. And then citing to the relevant section of the statutes. And then she gets into what clear and convincing evidence is. Evidence that indicates the thing to be proved is highly probable or reasonably certain. And then citing to this Doe case from 2018. Note, this is a state of Idaho Supreme Court case. Because remember, in diversity jurisdiction, you go with the federal rules of procedure, but state law governs on what must be shown in order to prove clear and convincing evidence and what it is. And then she goes on to state that Idaho courts have interpreted the statute to mean a claimant, that would be her, Professor Scofield, must show both a bad act and a bad state of mind, citing to Hall versus Farmers All Mutual Insurance Company. This is a 2008 Idaho Supreme Court case. And then quoting to this other case, Myers versus Workman's Auto Insurance Company. And then going into a bad act is established by showing that the defendant acted in a manner that was an extreme deviation from reasonable standards of conduct, and that the act was performed by the defendant with an understanding of or regard for the likely consequences. We're going to stop here, and we're going to pick up with issues at trial where the plaintiff is going to be arguing what she believes remains to be determined at trial by this future jury. If you have any questions, any comments, any thoughts relative to this matter, please leave them here. And until next time, my name is Kathy. Thank you very much for joining us here today.